Well, hello and welcome. My name's Davin Merritt. I'm an Australian patent and trademark attorney with the firm Phillips Ormond and Fitzpatrick, and I happen to be located in the firm's Melbourne office. Much of my day-to-day activities are centred around the design system because I head our firm's designs department. And I work for a lot of our overseas clients and associates in obtaining and maintaining their design protection. I'd like to have a look at the design system today, and particularly three aspects of the design system that I get asked the most questions about from overseas. And hopefully at the end of this presentation, which isn't particularly long, we're only looking at about 20 minutes or so, you'll have perhaps a greater understanding of these aspects and how you may be able to utilise them to protect yours and your clients' products. The three issues that I'd like to discuss today are multi-designs, the Australian Designs Grace Period, and the process of substantive examination for an Australian design, because it's a little bit different to many other countries. So we'll have a look at multi-designs first of all. We also happen to be New Zealand patent and trademark attorneys, so just out of interest, there is no multi-design system in New Zealand, if you were wondering, but there is now in Australia, and there has been for a while. So like overseas, you can file any number of designs in Australia in a multi-design application, just so long as those designs are found in the same Locarno class. They don't have to be in the same subclass, but so long as they're in the same class, you can lump any number of designs into the one application. Now, the Australian Designs Office provide a modest filing fee for the second design in a multi-design application onwards. So the first a design in a multi-design application will attract a normal $250 Australian filing fee. And each design application after that will attract a $50 discount. So you'll be paying $200 for the filing fee for each subsequent design in a multi-design application. One of the confusing aspects of the Australian multi-design system, and I compare it to the European design system, is that each design in a multi-design application in Australia has a completely unique, unrelated design number allocated by the Designs Office to all of its related designs in a multi-design application. So in Europe, you'll have a common number associated with each of those designs, and they'll all include a suffix 01, 02, 03 identifying each of the designs. We don't have that luxury in Australia. So if you ever receive multiple correspondence on the one multi-design application and we're identifying different application or registration numbers from the office, we haven't gone completely mad. It's just simply that the Australian Designs Office issue separate numbers for the various designs. And another unique aspect of the Australian multi-design system is that the Designs Office will issue a separate certificate of registration for each design of a multi-design application. So it won't be one design. If there are 10 designs in a multi-design application, you'll receive 10 separate certificates. So that's something to bear in mind. I'll talk a little about substantive examination shortly, but when it comes to a multi-design application, you can certainly request substantive examination, but you have to do so for each separate design of that multi-design. You can request substantive examination of one and not of the others. You can request substantive examination of all of them, but they have to be done on a design-by-design basis. And another aspect of the Australian multi-design system, which is worth noting, is that each design in a multi-design application are separately renewable. You only pay one design renewal fee in Australia, and that's at the 5-year mark to obtain the full 10 years worth of protection. But each design requires the payment of a separate renewal, and it's a full renewal. I don't want to discourage you from pursuing multi-design applications because it may be the strategy you're adopting overseas and you may want to adopt it in Australia, and you are able to do so because we have a similar system here. But there are limitations of the system. If you are filing a multi-design application on the assumption that will provide a cost saving over the life of the designs or the design registrations, it won't. I mentioned you obtain a $50 discount for each of the second onwards designs in a multi-design application, but we will match that if you filed each of the designs in a separate application anyway. And there are no cost savings at the formalities stage, registration stage, substantive examination stage, or renewal stage by lumping all of the designs in the one application as compared to filing them as separate applications. So cost shouldn't be the deciding factor in pursuing multi-design applications, but the system is there if you'd like it. And it also won't save you administratively. In fact, it can create a bit of a complex web of numbers because the Designs Office issues separate correspondence for each design in a multi-design application. So that's something to bear in mind as well. But the system's there and we're happy to assist you to use it if you so want to. Now, the second aspect of the design system I'd like to discuss today is that of the grace period. Again, I'll just briefly refer to New Zealand. New Zealand doesn't have a grace period available for designs. Australia, up until March last year, so March 22, we didn't have a grace period available either. But the Designs Act was updated and the grace period provision was included in the Australian Designs Act. And so now, if you or your clients were to prior publish inadvertently or perhaps intentionally a design product, that won't prevent you from pursuing protection in Australia for that design, so long as the design application is filed within 12 months of that first disclosure date. And the introduction of this grace period in Australia is great for a couple of reasons, or many reasons really, but two that I can think of is that previously, so prior to March 2022, our clients were able to obtain patent protection, valid patent protection for a product that they'd inadvertently disclosed. But because there was a grace period in the Patents Act, and there has been for many years, but there wasn't a corresponding grace period in the Designs Act. And so they were able to obtain patent protection for a product, but they weren't able to obtain design protection for that same product. Now that the grace periods for patents and designs in Australia have been largely harmonised, the client has the option of pursuing patent and design protection for that product, even if it's been inadvertently prior disclosed. So that's a good thing. And many of you will fully appreciate that other countries overseas, in Europe and US, for example, have grace periods for designs already. And the introduction of a grace period for designs in Australia now brings our designs law into closer harmony with those overseas jurisdictions. So that's a good thing as well. If you or your client have a product that has perhaps been prior disclosed a while ago, then you need to bear in mind and pay careful attention to when the first disclosure date was, because we only have 12 months from the date of first disclosure to validly file a design application in Australia, similar to overseas. But something to bear in mind, make careful note of when that first disclosure was and determine whether we can still rely on this grace period for you. The grace period covers a number of things. If your client inadvertently uses the product overseas or in Australia publicly within 12 months, we can still validly file a design application in Australia. If your client inadvertently publishes their product on the internet or in a journal or somewhere else within that 12 months period, we can still validly file a design application for you. But there is an important qualification that if that prior publication is by way of a foreign design for that product that is already published, either the design application somehow published or it's proceeded to registration overseas and published, that type of publication isn't covered by the grace period provisions. So be careful in that context. You'd have to rely on the 6-month window, convention window that's normally available to file in Australia, because you can't rely on the 12-month grace period. So that's just something to bear in mind. One of the things I would strongly discourage you from thinking about doing would be to rely on the grace period provisions in your normal filing strategy for Australia, because that's dangerous. And by that I mean if you were to normally, as a strategy, disclose your products and intend closer to the 12-month grace period deadline to file your design application then, which you're entitled to do, it opens you up to whatever your third-party competitors might want to do. So, for example, if you disclose your product either intentionally or unintentionally, and a competitor sees that product and starts commercialising it in Australia, before you get around to filing your design application, you can still file your design application and obtain registration, but you can't then enforce that registration on a competitor who has taken steps to commercialise it in the meantime. So bear that in mind. So I'd just say that, importantly, we've now got a grace period and you can rely on it if you have to in an emergency situation. The third aspect of the design system I'd like to talk about now is the substantive examination process in Australia. In New Zealand, if you file a design application, an examiner in New Zealand will look at it for formalities, make sure the drawings and everything's okay, the applicant's been suitably identified, and will undertake a prior art search. And only then, if the examiner is satisfied that it's a new and distinctive design, will he or she register it for you, and you'll obtain your certificate of registration. And that process in New Zealand was how it was in Australia up until about 2003, so about 2 decades ago. But the government of the day at that time decided that they would change the system and they would pull the substantive examination part out of the application process and dump it after registration. So now the system in Australia is reasonably unique insofar as you file an application, an examiner looks at it from a formalities point of view to ensure that the drawings are okay, the name and address of the applicant's been suitably identified, and the names of the inventors, or the designers if you like, have been identified. And if all those 3 aspects have been met, then the case will simply proceed through to registration and you obtain a certificate of registration from the Designs Office. If you want to request substantive examination of a registered design, you can. And in fact, anybody can request substantive examination of a particular design. Certainly the design owner can, and in most instances where substantive examination has been requested, it is by the design owner who now want to get their case substantively examined. The Register of Designs in Australia can, if he or she chooses, request examination of a case. I'm not aware that they've ever done that, but the option there is available for them to do that. And importantly, any third party, so any competitors of you or your clients out there who may want to question whether a particular registration is valid, can request substantive examination of a third party's designs if they want to do that. So it's useful to know that as well. I guess the question is, why would you want to request substantive examination? And there's an important issue to consider, that once you go through the formalities stage and the examiner grants a certificate of registration, that's an important step. But holding a certificate of registration itself doesn't allow you to go to the court system and say, I'd like to institute infringement proceedings against one of our competitors. The courts will send you away and say, no, we can only consider this once you have had the case substantively examined, and if you successfully pass through that examination stage, then the Designs Office will issue a certificate of examination, and once you've got that certificate, then come to us and we can hear the matter of infringement. What do you get if you request substantive examination? Well, primarily the examiner will undertake a prior art search, and they will seek to determine whether, in their opinion, the design is both new and distinctive. In my experience, most of the prior art that the examiner will find will be where the design owner has inadvertently, perhaps, prior published the design. Not very often that they find third-party relevant prior art. It's more where the owner of the design registration has perhaps inadvertently prior published the design. But whatever the prior art that is raised, if any is raised, it needs to be addressed within 6 months of the first report date. And if you can overcome the objection in this, any objections in the 6 months, the case will proceed through to certification. You'll receive your second certificate, which is that certificate of examination, and then you can go to the courts and chase an alleged infringer. It's important to note that if you do go down the substantive examination path, which again is optional, you only have that 6 months from that first report date. You can request a hearing at the Designs Office if you get close to the 6-month deadline and you haven't been able to resolve the matter with the examiner. But if you don't request a hearing and you don't resolve the objections the examiner's got, the case will simply be revoked. So it's a pretty important step, and 6 months can get chewed up pretty quickly, particularly if multiple examination reports issue from the examiner. Now, you've got a couple of options when it comes to substantive examination, and my clients who have multiple design filings in Australia usually fall into one of two categories. The first category is that group of clients who say, Davin, when we achieve registration of each of our designs, please automatically request substantive examination. We know that it's going to cost 970 Australian dollars to request examination. That's okay. We just simply want to, be confident that the case is enforceable by going through the substantive examination stage. And we also want to be in the position to immediately chase an alleged infringer when we become aware of any infringement, because we'll have that certificate of examination at hand already. And that's a perfectly good strategy to adopt. But other clients say, listen, Davin, we have a lot of design registrations. We don't want to spend $970 potentially unnecessarily on each of these cases. We will notify you when we're aware of an alleged infringement and seek to have that particular case examined, pay the $970 for that case, but we won't get the other cases substantively examined, thereby potentially saving the money for doing so. Is there a right or wrong way to go? There isn't. One strategy will perhaps save some money. The other strategy will have the design owners in a position to immediately pursue an alleged infringement. And it will, when I say immediately, I mean immediately. If you choose to wait until you find an alleged infringement, then have the case examined, there might be a 9-month delay or possibly more before you can actually pursue the case. But if you're satisfied that that's perfectly acceptable to you, then you may simply decide to just request substantive examination on an ad hoc basis. It's entirely up to you. That really is all I have to say about the Australian design system today. If you have any questions about the various aspects of the system that I've spoken about today, please feel free to get in contact with me. If there's any other aspect of the Australian or the New Zealand design system you'd like to discuss, again, I'm only too happy to try and answer the questions for you. Thanks for joining me, and have a good day.